Module Overview. Contracts are the backbone of agribusiness operations. Whether you're a farmer supplying raw produce, a cooperative processing goods, a logistics provider, an exporter, a distributor, or a retail outlet, your operations depend on enforceable agreements. This module delves into the full legal anatomy of agribusiness contracts and commercial transactions, their formation, execution, enforcement, breach, dispute resolution, and the broader legal principles that govern them under national and international legal systems. In agricultural contexts, contracts are not just legal instruments, they are mechanisms for managing risks, securing inputs, ensuring market access, stabilizing prices, guaranteeing delivery, and attracting investment. However, in many regions, particularly in developing economies, contract literacy is low and informal agreements dominate, often leading to disputes, losses, and exploitation. This module is designed to empower agribusiness actors to understand, draft, interpret, and enforce robust contracts that can withstand scrutiny and legal enforcement. Learning objectives. By the end of this module, you should be able to define a legally binding contract and identify its key elements, analyze different types of contracts used in the agricultural value chain, understand rules governing offer, acceptance, consideration, and intention to create legal relations, draft and interpret basic contract clauses in agribusiness settings, examine remedies and consequences of breach of contract, explore dispute resolution mechanisms including litigation, arbitration, and mediation. Assess the legal enforceability of oral, written, and electronic contracts. Understand the relevance of international commercial contract laws, e.g., CISG, UNIDROIT. Appreciate the role of fair trade principles, standard form contracts, and ethical contracting. Nature and importance of contracts in agribusiness. Definition: a legally enforceable agreement between two or more parties. Role in agribusiness: input supply, land leasing, labor hiring, commodity marketing, insurance, processing, storage, transportation, etc. Contract as a risk management tool. Essential elements of a valid contract: offer and acceptance, clear proposal and unambiguous agreement, consideration, exchange of value, money, goods, services, capacity, legal ability of parties to enter a contract. Legal purpose: the contract must not involve illegal activities. Intention: to create legal relations. Business agreements presumed to have legal intent. Types of agribusiness contracts. Input supply contracts: seeds, fertilizers, agrochemicals. Output marketing contracts: agreements between farmers and buyers. Land lease agreements: terms of land use between landowner and farmer. Credit agreements: lending terms with banks or microfinance institutions. Partnership or joint venture agreements, collaborative projects. Service contracts: hiring transporters, processors, or security services. Franchise and licensing agreements, agribusiness brand expansions, cooperative agreements, farmer group dealings and obligations. Key contract clauses and legal interpretation. Parties to the contract: duration and renewal terms, delivery obligations, payment terms and penalties, quality standards and specifications, dispute resolution clauses, force majeure, unforeseen events like floods, droughts, termination and exit clauses, confidentiality and intellectual property clauses, contract formation and formalities. Oral versus written contracts in rural agribusiness: use of witnesses, notarization and legal registration, digital contracts and e-signatures under e-commerce laws, legal capacity of cooperatives, partnerships, and companies. Breach of contract and remedies. Types of breach: minor material anticipatory remedies, damages, compensation for losses, specific performance, court orders, party to fulfill obligation, rescission, contract cancellation, restitution, return of benefits received, legal defenses, mistake, misrepresentation, duress, illegality, frustration. Contract dispute resolution in agribusiness. Litigation: court-based resolution, formal but costly. Arbitration: quicker, private, often contractually required. Mediation: voluntary settlement with neutral facilitator. Role of agribusiness tribunals or local customary forums. International and regional contract law instruments. CISG, Convention on the International Sale of Goods. UNIDROIT, Principles on International Commercial Contracts. OHADA, Commercial Laws in Francophone Africa. AFCFTA provisions on cross border agriculture, trade contracts, enforceability across borders, and jurisdictional issues. Fair trade and ethical contracting, addressing exploitation and inequality in agricultural contracts, gender sensitive clauses and women inclusive terms, environmental and social responsibility clauses, transparency and readability in smallholder agreements. Challenges in agribusiness contracting, illiteracy and low contract awareness among smallholders, informality of rural markets, enforcement gaps in rural justice systems, power imbalance between corporates and farmers, cross border enforcement complexities. Case study examples: Kenya, dairy farmers suing a processor over unilateral price changes. India, contract farming disputes under the Model Farming Act's Nigeria. Land lease agreement disputes between youth agripreneurs and community elders. Brazil, sugarcane producers in arbitration over breach of supply agreements. Key takeaways: contracts are the legal lifeline of all agribusiness transactions. Understanding the elements of contract formation is essential to avoiding exploitation and disputes. Formalizing agreements enhances access to finance and legal protection. Dispute resolution mechanisms must be accessible and appropriate to the context. Ethical contracting ensures long term relationships and social license to operate.